Imagine a juror who does their own research on Google Maps to construct their own digital copy of a crime scene. One who researches Canadian laws outside of those discussed in court, believing they can better understand the legal system. Though the juror's actions may seem harmless, they have the power to deprive a defendant of their charter-guaranteed rights, triggering a mistrial and derailing the justice system all in just a few clicks. This is Trial by Google. Over the last few decades, technology has progressed at an accelerating rate, allowing information to be accessed at our fingertips. The internet revolution has led to an increase in technology addiction, with recent polls suggesting that over 60% of the North American population is addicted to the internet. Despite judges routinely cautioning jurors not to conduct independent research on the case, such instructions are sometimes ignored. In addressing the issue of jurors conducting independent research, the Ontario Court of Appeal acknowledged the risk, stating, "In this information-rich age, devices able to access the internet are ubiquitous. Technology use has had dire consequences at courtrooms nationwide, with jurors conducting external research on cases they sit on through the internet, something that constitutes as juror misconduct." Juror misconduct can take many forms, including communication by jurors with those outside the court case, including the internet. Such action may introduce outside information into a trial which has not been allowed by the judge and which may influence the Googling juror or the entire jury if the information has been shared. Jurors are charged with the responsibility of deciding if an accused is guilty or not guilty of the offense for which they have been charged. The jury must reach its verdict by considering only the evidence introduced in court and directions given by the judge pertaining to legal decisions or excluding evidence from their deliberations. Through this process, the jury must remain impartial and independent, meaning they must not be influenced by outside factors. The use of the internet has the potential to interfere with jurors' decisions. Googling jurors may find details that the judge has not allowed, or be exposed to external opinions that may reduce their impartiality and influence their decisions. A juror found to directly disobey a judge's instructions regarding conducting their own research into the specifics of the case can be held in contempt of court. This offense, while codified in Section 484 of the Criminal Code, relies heavily on common law and applies to anyone who willfully disobeys a process or order of the court. The offense is punishable by a summary conviction. However, Osgoode Law Associate Professor Lisa Dufresmont states that while there is a threat of contempt of court, prosecutions are rarely made relating to conducting one's own research. Looking further at the Criminal Code, if a jury's decision is in question, judges, under Section 649, can question whether outside sources, such as information from the internet, was attained by a juror. This section does not, however, permit the courts from receiving any evidence regarding how the jury came to their decision, and thus the impact of a juror's independent research on the decision reached would not be known. The ratio decidendi of the R.V. Sawyer case held the constitutionality of this section as not infringing on an individual's legal rights. As a result of the circumstances, there have been multiple cases in which juror misconduct through the internet has interfered. In the case of Patterson v. Pellado, a juror admitted to researching Section 17.2 of the Insurance Act's fault determination rules, which was not presented as evidence during the case. The judge, however, did not order a mistrial as they believed a corrective charge to the jury to discount the evidence would suffice, with the juror-introduced evidence not expected to affect the jury's final decision. In a second case, a lengthy manslaughter and assault case in Bradford was declared a mistrial in 2018 after a juror conducted research on parties involved in the case. Internet usage by jurors to conduct individual investigations has a clear impact on charter-guaranteed Section 11D rights of a defendant. The section states any person charged with an offense has the right to be presumed innocent until proven guilty, according to law, in a fair and public hearing by an independent and impartial tribunal. The concept of a fair trial is fundamental in the Canadian criminal justice system. Fairness manifests itself in the basic principle that a criminal defendant's innocence or guilt must be determined from evidence in court. It is not for the jury to do its own research outside of the courtroom. Such research would reduce the independence and impartiality of jurors as they are being assisted in a decision by external material with a possible bias. There are important reasons why a jury may not be presented with all the available information and evidence in a given case. The current rules of evidence have evolved over decades and are specifically designed to ensure that the facts heard by a jury undergo examination and challenge by each side. Finding evidence by oneself and not allowing it to be challenged interferes with this due process and impacts the right to a fair trial. Corrective charges can be made by judges to tell juries to discount information provided by internet searching jury members. However, a psychological study showed that even if jury members are told to discount evidence, it can still subconsciously influence their decision making. Thus, by simply issuing a corrective charge to a jury to ignore evidence a juror obtained from the internet could severely compromise a defendant's Section 11D rights. Another issue arises from the previously discussed Section 649 of the Criminal Code, which does not allow the court to obtain information on what influenced the jurors to reach a certain verdict. Thus, if a juror does introduce internet information, the effects on the jurors would be unknown, further demonstrating the ineffectiveness of a corrective charge in protecting a defendant's rights. The Pelledo and Bradford case were both impacted by juror misconduct, and thus the defendant's charter-guaranteed rights were severely compromised. In the case of Pelledo, the jury was told to ignore the juror-introduced evidence, which, by using the data from the experiment discussed, could still significantly impact the rights of Pelledo. In the Bradford case, a mistrial was declared. The judge determined it was necessary for the trial to be redone with a new set of jurors to prevent a miscarriage of justice. This, however, introduces a new impact of juror misconduct on the defendant's rights, being the right to be tried within a reasonable time, protected under Section 11B of the Charter. Mistrials significantly back up the legal system, which compromises defendants' 11B rights. In addition, mistrials have a significant financial impact as they can cost taxpayers tens of thousands of dollars. With drawbacks to both continuing a trial with a charge to disregard juror-introduced information or declaring a mistrial, judges must navigate a complex decision-making process that will include a judgment call on the potential impact of the information. Due to the ever-growing nature of the internet, the problem of jurors Googling for outside information must be addressed as a common and real risk which challenges the integrity of the justice system moving into the future. At any given moment, once they leave the court, jurors have the ability to use their cell phones to browse the internet for information on the parties involved in the case, examine Google Maps, or browse biased web pages for legal explanations and media opinions. This will only become more readily available as society becomes more reliant on technology and as the internet expands. There are a number of ways in which the risk of the Googling juror can be reduced. Judges must specifically tailor their jury instructions to make sure juries are aware that researching on specific sites and in specific ways on the internet constitutes misconduct. For example, crime scene reconstruction on Google Maps, or using social media platforms to learn about a party in the case. The only way to adequately educate jurors is to make instructions very precise in explaining what they may and may not do while engaged in a trial, and explain the legal consequences of disregarding the instructions. Lisa Dufresmont even states, "I think it's still possible for juries to follow instructions," demonstrating the potential for this solution. In addition, technology usage can be taken into consideration in scientific jury selection techniques. By analyzing certain demographics' susceptibility to internet dependence and addiction, lawyers will be able to select jurors with lower chances of compromising the rights of the defendant by internet researching. For instance, senior citizens and smokers are less likely to be addicted to the internet than young adults and non-smokers, and thus a jury composed of the former demographics may be less likely to conduct their own research on a case. If a juror's independent research continues to threaten the fairness of trials, laws similar to the United Kingdom's Juries Act should be adopted. This act makes it an offense for a juror to intentionally seek out information relevant to a case. The codification of internet research as an indictable offense will likely lower its occurrence, as currently, contempt of court laws in Canada are based on case law and only punishable by a summary conviction. In conclusion, as internet usage grows, there will be an increase of jurors conducting their own case-related internet research, and thus, the impact on the Charter-guaranteed legal rights of Canadian citizens will become more severe. The issue must be identified as critical for the future of the integrity of the justice system, and solutions such as those discussed, and possibly others, must be considered and implemented in a formal process. Justice can only be achieved when Google is no longer a member of the jury.